from the earlier videos that a patent gives an exclusive monopoly right to the patentee. In other words, it excludes others from making, using, selling, offering or sale, for even importing the patented invention without consent. And if done so, it would amount to patent infringement. So what is a patent infringement? Well, it is the violation of patentee's right to the invention within the country of a patent grant and during the patent term. Section 104 to 114 of the Patents Act 1970 provides guidelines relating to patent infringement. Enforcement of a patent is rather a large subject. This course attempts to bring out some of the important principles underlying infringement, like what does or does not constitute infringement and remedial measures available to the patentee in case of infringement. Let us consider some of the case illustration. In one of the automobile patents infringement case, Bajaj Auto Limited had brought an action against TVS Motors Company for allegedly involving an unauthorized use of Bajaj's patent on digital twin spark ignition system (DTSI). Though the parties eventually entered into a settlement, its importance lies in the judgment of the Supreme Court, which directed the courts in India for speedy trial and disposal of IP-related cases. In another case, the Swedish telecom firm Ericsson had filed a lawsuit against Xiaomi alleging infringement of 8 of its standard essential patents used in technologies for mobile phones. The Delhi High Court had granted an interim injunction directing Xiaomi to stop sale of its devices in India. There have been several cases of patent infringement in the pharmaceutical industry as well. One such case was of Hoffmann La Roche versus Cipla, case that was filed before the Delhi High Court. Roche along with Pfizer had claimed to have a patent on a drug called erlotinib. It was considered as a breakthrough research in treatment of cancer. The drug was approved by the US Food and Drug Administration (FDA) and thereafter by European Union. It was also patented in India. Cipla, an Indian pharmaceutical company, launched the generic version of drug. Roche filed a suit against Cipla for infringement of its patent. The Delhi High Court dismissed the case on the ground that since the drug manufactured by Cipla was a life-saving drug, that was 3 times less price than the drug manufactured by Roche. It was purely in the public interest. So to file an infringement suit, there must be a prima facie validity of the patent and also prima facie infringement should be proved. While assessing patent infringement, it is important to first ascertain whether the person alleged of infringement has actually violated the rights of a patentee. A person would be liable only if his product or process is same as the patented invention. How can this be ascertained? Well, this is done by understanding the meaning and scope of the claims in the specification. Technically, it is called claims construction. Next, the patentee has to prove that the rights were exercised without his authorization. And 3, the patent must not have lapsed or expired. It's also important to note that the Indian Limitation Act 1963 prescribes a limitation period of 3 years for bringing an infringement suit. Suppose the patent has ceased to have effect because of non-payment of renewal fee. Then the patentee cannot institute the proceedings between the date on which the patent ceased to have effect and date of publication of the application for restoration of a patent. Based on its nature, patent infringement is broadly classified into 2 types, direct and indirect infringement. We shall discuss them in further details in the next video.